today is going to be about section F. Just giving it just one more minute because we did have a few technical issues at the beginning, and then we will start. But we will be talking about section F, which is provision in your EHCP, a very important part of the EHCP, which as parents you need to look at very carefully and need to be questioning some of the proposed wording of the local authority in many cases. So I will now begin. So today we're going to cover what is section F provision and how to check for correct wording. So SEN provision required, the SEN provision that's required by the child, additional provision or training, it can be occupational therapy, speech and language therapy, it can be one-to-one support, it can be specialized teaching. The key things, if you remember from this presentation, are that it must be specific, must be quantified. So it needs to, if a child or young person, for example, needs social speech and language therapy or social skills group, the section F must state the number of hours, the size of the group, the sort of training that's going to be described, and the programs that are going to be delivered. So each section B of an EHCP, which deals with needs, is a very important part of the EHCP. Every need identified in section B should have a mirror provision in F. So it can be therapy. Do not let local authorities get away with the suggestion that occupational therapy and speech and language therapy are health provisions. If your child or young person needs speech or language therapy or occupational therapy, then these are educational provisions and should be in section F. The fact that they may be delivered by NHS staff is neither here nor there. They are educational provision and must be in section F. A blanket policy not to specify and quantify in section F, which some local authorities still seem to do, is unlawful. So I'm going to give you some examples here. And at the end of this presentation, or this evening when you're having your glass of wine, it's a Friday night, or whatever tipple you fancy, look at your child or young person's EHCP and see, is it lawful? So here's some examples. Emily may benefit from small group and or one-to-one phonics sessions. Well, the words may benefit should never be in an EHCP because we'd all benefit from all sorts of things. A lot of us today would benefit from a holiday in the sun or a cruise in the Mediterranean or indeed the Caribbean, but we don't need it. We can, as we are all discovering, live without that cruise in the Caribbean. So Emily may well benefit, but it's meaningless. It has to say Emily needs. Now, small group, what's a small group? I've come across local authorities who think a small group is 15. I would think a small group is no more than 3 to 5. So whatever the small group is, and of course for social skills, you do need to have a small number. So 5, 6, whatever it is, or 3, it needs to specify. And one-to-one phonics sessions, well, we've now got one-to-one session. We know it's going to be one-to-one. Who's going to be delivering these phonics sessions? Is it a teacher? Is it a teacher qualified and experienced or qualified and having the MA in dyslexia teaching? And how long are these sessions to take place? Is it 10 minutes, 30 minutes, 1 hour? And how often are they to take place? Is it once a week, once a fortnight, once a month, once a year? Because in this, if Emily did not receive any social skills work in a small group or any one-to-one phonics sessions, it seems to me it's very difficult for parents to challenge this because nobody knows what's going to be delivered. So I hope that all of you listening today can see how vague and hopeless that is. So the next one, the speech and language therapist should devise a programme for school staff to deliver to be reviewed on a termly basis. Well, the speech and language therapist is going to devise a programme, and how long are they to spend doing that? And who are which school staff are going to deliver it? And how often are they going to deliver it? Is the delivery going to be by a TA or an experienced TA, whatever an experienced TA is, or by somebody else? And it's going to be reviewed on a termly basis. I'll pause there. Termly basis can mean different things in different parts of the country. Some parts of the country now have 6-term years. Sometimes, so each half term, is in old money, is a term, and some local authorities still have 3 terms. So what is a termly basis? Don't know. Emily may require additional adult support in lessons. Well, may require. What is may? She might not. How are you going to enforce that? Who knows what that is? And what is additional support? Is it by an experienced TA who's got some sort of qualification, or a TA that has experience in dealing with children or young people who have dyslexia, if your child or young person has dyslexia, or autism if your child has autism, or whatever the diagnosis is. For example, if your child or young person has a medical condition, then it may be that you want the TA to have some first aid qualification. So Emily should have regular access to a small group motor skills program for 1 term, and then reassess to determine if a further term of input is necessary. So regular, what is regular? Well, regular can mean all sorts of things to different people. Regular might mean once a day, twice a day, once a week, once a fortnight, once a month. Who knows what regular is? Access means might happen, might not. Small group, what's the small group? How big? And what is this motor skills program? And generally, things should not be reassessed, because you have an EHCP that's meant to last for 12 months. So it should be clear what's going to be delivered over the next 12 months. So all of those examples that you see there are unlawful and have been taken from real life EHCPs. To give you an example of what should not be in an EHCP. Why local authorities continue to produce EHCPs which are unlawful because they're not quantified or specified, I have no idea. So it's quite clear that Section F should specify clearly the provisions necessary to meet the needs of the child. It should detail appropriate provisions to meet each identified need. So what you want to do is look at your EHCP, look at all the needs in B, and make sure that there is a mirror provision in F. It must be detailed and specific, should normally be quantified in terms of the type, hours, and frequency of support and level of expertise. The local authority must determine the special education provisions that may be necessary rather than leaving this for future assessment. Section F must be so specific and so clear as to leave no room for doubt as to what has been decided and what is needed. If you look at your EHCPs and you think, not quite sure what my child should be getting here, and if the local authority don't make the provision in F, can I enforce it? Can I say you're not making the provision in F, or is what is in F currently not so unspecific, and it is so unclear and leaves so much room for doubt that nobody knows what they should be receiving. So we've already said detail must be specific, must be qualified. So I'm going to just deal with a few. We had some examples before taken from real life EHCPs. Here's some from some case law. Support from a learning assistant said nothing about how much or training or experience. That's obviously unlawful. Program to develop his social communication skills, failed to say anything about the nature, content of the program, who was delivering the program, what it was, how often, what was the group, etc. Opportunities for is vague, meaningless, and unenforceable, and therefore unlawful. So if you have opportunities to buy that lottery ticket tonight, what does that mean? You might buy one, you might not. What you want is something specific. The equivalent of the 25 hours, and this next one is one that you will find in local authorities producing, the equivalent of 25 hours of support to be used flexibly across the school day to include individual, small group and whole class teaching to meet the outcomes described is vague and lacks the required specificity. What is meant by equivalent? Who is to provide the support? That is just utterly meaningless and utterly useless. It should say one-to-one support for 25 hours. you can't have the equivalent. It's meaningless. So any provision in F needs to be specified and quantified to require focus and express consideration to be given to the specific needs of a child, and then to provide for them in terms which will further and affect its enforceability as a provision. It is not permissible to leave provision unspecified or unquantified simply to allow for flexibility in the school's approach and arrangements. So watch out for some common problems here. We've got your top 6, top of the pops, for those of you who are young enough to remember it. Small group. What is a small group? Is that 3 or 20? Not quantified. Words like as appropriate, as required, regular, periodic, subject to review, all of those should not be in F. Provisions which have no indication of who will facilitate it and what training they will have. I mean, what is a general TA? Sorry, in some parts of the country, I know that you call teaching assistant or LSA, learning support assistant, whatever the name given, it's the support in the classroom. Provisions which have no frequency or duration, this is not specified or quantified. Vague wording, any wording which says likely to benefit. I think we've already dealt with likely to benefit. I'm still likely to benefit from my cruise, but I'm probably not going to get one anytime soon. This is unlawful. The provision must say your child's needs. Differentiated curriculum. What does that mean? Need to explain what curriculum is required. So these are the themes that everybody on here is going to remember tonight. It must be specified. It must be quantified. Provisions should be easy to follow so that you, your child, and the school have a clear understanding of what support and provisions are in place. EHC plans which are vague do not satisfy this. If you're confused with your EHC plan, if you're confused what your child and young person should be receiving, it is likely that it has not been specified or quantified correctly. So the EHCP must answer the following questions: what, who, when, how long? So when local authorities are drafting the HCP, if these questions are not answered, go back to the local authority and ask for further clarification and say, what is being provided, who is providing it, when are they providing it, daily, weekly, monthly, and how long is each session? Section F should be labelled the special education provision required by the child or young person. And if you're at home looking at your EHCPs tonight with your little tipple, just draw a column and look at the provision that said be provided, and then have a second column on your little pad saying by whom. It should be easy to see what the provision is and who is providing it. Every EHCP has 4 main sections: communication and interaction, cognitive and learning, social, emotional and mental health, sensory and or physical needs. And those are the different headings. If your child or young person has a need in section B of communication and interaction, then there must be a provision in F. If your child or young person has a need in cognitive and learning, your child must have a provision in F under that heading. If your child or young person has a need in social, emotional and mental health, then you need to have a provision in F. Often social, emotional and mental health, the provision seems to be missed out. Sometimes local authorities identify the need, but they don't then make the provision. So sensory and or physical needs, if your child has a need identified in section B, you need a provision in F. As I said at the beginning, the provision in F needs to mirror. I often say it's like the other side of a book. So with your notepad, on the one side you have the needs, section B, and on the other side of your page of the book, you will have the provision. It should not be in the first person. It was always say the child's name. For example, Dina Asher Smith needs visual aids, etc., or requires visual aids, whatever it is. Remember, the thing you're going to remember tonight, if you remember nothing else from today, is all provisions must be specified and quantified. I'm just going to deal briefly with education other than school. So basically, the local authority has a duty to make suitable alternative arrangements for children of statutory school age who cannot attend school because of illness, exclusion, or any other reason. If it can be shown that it is not reasonably practical for a child to attend, the local authority's duty to provide suitable alternative education arises. So if it's education otherwise at school, in section F, it must have the provision that is going to be provided. And education otherwise than at school is also identified and set out in section F. And this is because education otherwise than at school cannot be named in section I. So I can be, if you have education other than at school, section I will be blank and it's simply in F. So children do have, parents do have the right to educate children at home. The local authorities should fund the SEN needs of home educated children where it is appropriate to do so, but they do not have an obligation to do so. I won't dwell on that one too long. So if you're preparing for an education otherwise than at school argument, you're almost become an accountant. You need a full costed provision map of what you want. You need all the details of the courses, books, equipment. You need to consider the cost of tutoring, whatever it is you want, external activities. You need a proposed timetable. You need a statement describing your education philosophy and the practical arrangements for implementing it. Evidence of the qualifications or experience of either you or the tutors you're using. Reports by educational professionals who have visited the home or and formed an opinion that may be helpful, and reports from tutors can be helpful. You can have a personal budget for some needs. This can be requested when the draft EHC plan is being prepared. For example, speech and language therapy and occupational therapy are pretty poorly provided, and local authorities seem to struggle to make provision in section F of some things. So you can request that the local authority give you a personal budget so that you can then make that provision. But local authorities can refuse personal budgets. Any provision in section F should be set out, but you don't detail costings in section F. What do you do if the local authority does not make the provision in section F? So let's say that we have in section F that Dean or Asher Smith requires speech and language therapy once a week for 45 minutes from an experienced speech and language therapist, one who has expertise in working with young children who have similar needs. And that should be every week, as we said, for 45 minutes. What if the local authority don't provide it? Well, you don't have the right to appeal to a tribunal over that lack of provision. And as parents, I'm afraid that you do need to keep your eye on local authorities, because having finally got your EHCP and having finally got your EHCP, which has got it's got good quantified and specified provision in section F, what can you then, what can you do if the local authority, you've had that battle with them, you've got your quantified and specified EHCP, but they then don't make the provision? Well, your recourse is to threaten judicial review, because the local authority are in breach of their statutory duty. Everything that is in F, the local authority have a statutory duty to provide. And that is why it needs to be quantified and specified, because if the local authority don't provide it, we know that you can then bring proceedings or you have the right to say you're in breach of your statutory duty and responsibility because you've not made the provision that's in F. If it's, for example, speech and language, so you need, first of all, to send a letter before action threatening judicial review. In my experience, a letter before action does the trick each and every time. You never actually have to issue judicial review proceedings, because the local authorities know that they have the statutory duty to make that provision. if they don't, they are in breach of that statutory duty. If a local authority doesn't make that provision, there's a recourse, as I've said, is a letter before action and possible judicial review proceedings. What if a local authority says, oh, we can't find a speech and language therapist because Dean Asher-Smith lives in a rural area, the school is miles from everywhere, there's no available speech and language therapists, and there's no available speech and language therapists at the NHS. They've had a crisis at the NHS, all the NHS speech and language therapists are ill, or they're not available, or whatever. Well, the local authorities still have to make that provision. I can recall one case where it was actually speech and language therapy. Local authorities said, we can't find any speech and language therapists in the vicinity, we can't make the provision. That's our justification for not making the provision. So what you then need to do is go and find an independent speech and language therapist who is willing to make the provision. And it doesn't matter if they have to travel 100 miles away. The local authority have that duty, and they will need to pay the travel of that independent speech and language therapist to come to the school to make that provision, which is in the HCP. And in the case I'm thinking of, the local authority had to employ a speech and language therapist from considerable distance. I think it was something like 100 miles. They fairly quickly found that speech and language therapist delivered the speech and language therapy for a while, and then the local authority did manage after a few months to find one locally. The other thing to keep your eye on is when speech and language or occupational therapy is said to be delivered weekly, and then what often happens is there are missed sessions, not because of your child or young person, but because the speech and language therapist or occupational therapist is ill or is on holiday, or whatever the reason. Those sessions need to be made up, because it should be once a week, and that would make, let's just say, 10 sessions per term. And if your child or young person's only received 6 per term, that's fairly hopeless. Local authority need to make up those sessions. And if they don't, if they're not willing to make up those sessions, again, it is the threat of judicial review and judicial review proceedings if necessary. But in my experience, local authorities would never go to judicial review, because they'd never go to those court proceedings, because they know that they're in breach of their statutory duty and they have no defence. That is why it is absolutely vital that when you look at your EHCP, you ensure that it is quantified and specified, because if it isn't quantified and specified, how are you to justify, how are you to enforce something that is vague, may require, may need, may benefit? How are you going to justify that? The local authority will say, we're not in breach of our statutory duty, because it just says may need or may benefit. That's why it must be quantified and specified, so that you can, if necessary, enforce the provision. If you are legal aid for a letter before action, legal aid may be available to parents if they are financially eligible, which means generally on a low income. If proceedings actually became necessary, then legal aid for court proceedings may be available in the name of the child. But as I've indicated, usually local authorities will give in. So that is a very quick canter through different the points to remember when you are looking at your child's EHCP Section F. So if you're having an annual review and you've looked tonight at your EHCP and you don't think it's quantified or specified, then you need to ask for the EHCP to be amended so that it is quantified and specified. If you've just got a draft EHCP, then your representation to the local authority will be it needs to be quantified and specified, otherwise it's unlawful. So whichever stage you're at with the EHC process, raise the issue with the local authority that the Section F provision must be quantified and specified. And I have been dealing with this work for 25, 30 years. I have never seen an initial final EHCP, or in the days when we had statements, where Section 3, if it was a statement, and Section F if it's the EHC plan, was in the first stage lawful, quantified and specified. Local authorities, whichever part of the world you're from, continue to produce documents which are basically unlawful. I've spoken about section F because I'm throughout this presentation, because I'm referring to EHC plans. However, the principles also apply to part 3 of a statement of special educational needs, which applies in Wales. Wales will be moving to a new system in September, but unfortunately the details are a bit sketchy at the moment. We will nearer the time do a presentation on the Welsh changes once we've had some code of practice and the new code of practice and new regulations, but they aren't out yet, so we don't quite know what's being proposed. I envisage that it will be something similar to the EHC process, but they'll want to use different wordings. But that likely to be similar is my guess, but I don't know. So that is section F of the EHCP. Are there any questions, Emma?
Yes, as always, we have some very good questions. So the first question is, who has the right to add the quantity and specification to section F?
Well, basically what happens is when you get your draft EHC plan, you respond to the local authority, and what you should do is ask for the draft EHC plan as a Word document, and then in your comments and track changes, you put in comment. Currently, this is not quantified or specified and therefore unlawful, and then in the track changes, put in what you want. So it's the parents that make the representations. And if the final plan is issued, still unquantified, still not specified, then you have the right of appeal to an SEN tribunal. And an SEN tribunal will make sure that that provision is quantified and specified. If you appeal against section F because it's not quantified or specified, then usually local authorities will give in. They won't go to an actual appeal hearing because they know they're going to lose. So it's the parents that make the representations, and the parents have the right of appeal. If your child or young person is under 16, technically if your child or young person is 16 over, then it's in the name of that young person. That's not to say the parents won't be involved in the appeal, obviously they are. You would lodge an appeal to a special needs tribunal saying section F needs to be amended because it's not quantified or specified, and if it did go to an actual tribunal hearing, which many of those sorts of cases will not, then you will a tribunal would order quantification and specification. But in my experience, local authorities, if you appeal, they know they're, if I put it, bang to rights, and they have no defence, and they will usually give in at that stage if they haven't given in before. In many cases, if parents make representations on the draft EHCPs, they will make some amendments. It just depends on the local authority. I hope that answers that question.
Okay, so the next question is, please can you, if there are many provisions, so if you have quite a lot of provisions that you're requesting, can the local authority or tribunal say the EHCP is too lengthy at all?
Well, I think it's at this stage, we used to have, when we were dealing with, when we held our information days where people attended, for a box of chocolates, people had to guess what was the longest EHCP that we had ever come across, and the person who got closest to that number won the box of chocolates. But we can't, that can't be done on this sort of format. The answer is the most lengthy EHCP I have seen is over 100 pages. So tribunals sometimes say this is quite a lengthy document. But if a child has a lot of needs and a lot of provisions, it's going to be a lengthy document. But I would have thought 30, 40 pages is not unusual, anything around that. When it gets longer, as it's meant to be a sort of document that anybody can pick up and know what the needs and provision are for a child or young person, it can get a bit difficult. But a tribunal is never going to say, or we're not going to give speech and language therapy because there's already a lot of provision in section F. and it's a lengthy EHCP, they're going to look at each and every need and see, is there an appropriate provision? What is the appropriate provision, and put that in F. You don't need to slavishly put everything that's in any report into your EHC plan, because your report should be annexed to the HCP as part of the documents mentioned in section K, but you do need the provisions set out in section F. Next question.
Okay, how do you make sure that the provision is actually being delivered?
Well, that's another good question. You're not in school. You have to, it depends what the provision is. If it's, for example, speech and language therapy, then you would be wanting to be in touch with a speech and language therapist. You want to know from the school or therapist when they go in. Often they are giving programs for the next week to the learning support assistant, or however long it's going to be, and you would want to know what those programs are so that you can also practice those possibly at home. So if it's occupational therapy, physiotherapy, I mean, it is difficult as a parent, particularly depending on your child's difficulties, because if, for example, they're non-verbal, or they have limited verbal communication skills, then you might not get the answer from the child. So you need to keep on top of, if there's a communication book going between school and home, say, you know, did Dina Asher-Smith have speech and language therapy on Monday? Did Dina Asher-Smith have physio on Thursday? So you need to keep on top of it, whatever it is. It can be difficult to work out when the child or young person's had what, depending on the circumstances.
So the next question is for education other than at school, how does that work in principle for a person who's over the age of 16, who's not in education, employment or training, and school refuses on the basis of anxiety?
Well, school refusal on the basis of anxiety is a classic case where education otherwise than at school may be very appropriate. So what you would need to do is to set out, what would your child or young person, if they're over 16, what provision would they need? So do they need English tuition? If it's English tuition and they're hoping to take, for example, English GCSE, then let's have English twice a week with a tutor. So we've got a timetable, draw up a timetable, say Monday, I want English tutor to come to the home for 1 hour. Then I want the maths tutor to come to the home for 1 hour. Then I want some perhaps therapy, or counselling, and that will be another hour. And then we'll do a bit of rebound therapy, or whatever it is, or might be horse riding, whatever it is that you draw up a timetable, first of all, of what provision you consider could meet this young person's needs. Then you need to set out what the cost of that provision would be, and then you need to ask the local authority to pay it. So you set out all the provision, you set out a timetable with the provision in it, and then you set out a list of what that's going to cost, and then you go to the local authority and say, well, look, here's the timetable, this is what I'm proposing to deliver, and here's what it's going to cost. Can you please give me a personal budget? With personal budgets, there can often be some negotiating with the local authorities. There can be a bit of to in and fro in, you know, well, we'll pay for this, but not that, or that's a bit much. So, and it's a bit of compromise, but usually with most local authorities, you can reach an agreement.
Okay, so the next question is that on this person's EHC plan under section F, which we see very, very commonly, it says, how will this be delivered? The curriculum will be delivered via a combination of one-to-one support, small group and whole class teaching. It then says funding source, resources ordinarily available to schools. They're assuming that this is not good enough. How do I get the LA to change this? They refused when the last SENCO changed.
So the answer is, when you have your next annual review, you say you want this change because it's not quantified, it's not specified, it's unlawful, and you need to set out what the wording is that you want in there. You want to, prior to the annual review, And we did a session on annual reviews yesterday, which will has been recorded and will be up next week. So have a look at this. Prior to the annual review, you submit a document at least 2 weeks prior to the annual review, setting out your parental views and concerns. And part of those parental reviews will be your concern that section F of the HCP is unlawful because it's not quantified or specified, and it's not clear what provision your child is to receive. So just read that out again, Emma.
So the wording is the curriculum will be delivered via a combination of one-to-one support, small group and whole class teaching. And then it says the funding source is resources ordinarily available to schools.
Well, funding resource shouldn't be in an EHCP anyway, because how it's funded is irrelevant and doesn't need to concern you. What that whole bit is meaningless. It doesn't mean anything. So you need to decide what it is you want, and you want it more quantified and specified. If after the annual review, the local authority, you say you want amendments to the HCP, and these are the amendments you want because you're concerned, if the local authority decide not to make the amendments, then you have a right of appeal. As I've already said, an appeal, a special needs tribunal will most definitely say that should be quantified and specified, because this knows what it is your child's meant to be receiving. And local authorities are likely to give in beforehand. So you've got to go through the process. The way to change an EHCP is through the annual review process. If you're at crisis point, which sometimes happens, that the provision is so hopeless and the young person is in crisis, then you may have grounds for requesting an urgent annual review. But if it's not a crisis point or not a sort of transition point, then you do, at the annual review, you can ask for changes to the HCP. And one of the changes that you should seek would be that section F is quantified and specified, and set out the wording you want. It may be that that's the sort of case where you might want to think about, if you can, an independent educational psychologist report to look at and to observe, to assess your child or young person and make sure that all the provision in F is appropriate. They may well advise and recommend further provision. And they would also observe the child or young person in the classroom as well to see if they are accessing education appropriate, and make recommendations about the exact provision. And they should quantify and they should set out in their report what provision is required to meet the needs in a quantified and specified way. So the answer is you probably need to go through the annual review process. If you're concerned that you're 6 months away from an annual review, and you're concerned that your child's really receiving absolutely very little support, and this is section F is all meaningless and hopeless, then you can request an early annual review and say, I'm really concerned, my child's not making the progress they should. I'm concerned they're not receiving the provision they need. I want an urgent annual review. And then following the annual review, you can say, I want amendments to the HCP. The local authority will send you a notice indicating whether they're going to amend the HCP or not. If they decide to make no amendments, you have the right of appeal. If they decide to make amendments but you don't agree with them, you have the right of appeal as well.
Okay, so next question. What happens if provision is in section F but the school refused to do what's in there?
Well, a letter before action. They can't refuse. Basically, the EHCP is a statutory document which the local authority have a statutory duty to make that provision. So in fact, the body, if I put it this way, which is in breach of that statutory provision is the local authority, not the school. But the local authority are going to feel slightly miffed, and they will put pressure on the school to say you must make this provision because they are the ones who have to respond and answer to any court proceedings because they're in breach of their statutory duty. The school might well be joined as a party if it actually went to court. That sort of case would never go to court, but technically the duty falls on the local authority. If the local authority don't make that provision, then the local authority are the ones who would be the party that would be served with judicial review proceedings. They are the ones who would send a letter before action to, although it's the actions of the school acting as, in essence, the local authority's agent who are not making that provision. So it falls back to the local authority. So you have to go send a letter before action to the local authority and say, look, this school's not making the provision. And if you don't ensure this provision is made, we're going to bring judicial review proceedings. And the local authority should then act and make sure that the school makes the provision.
So a similar question, if you have a final EHC plan with specified and quantified provision, but the local authority say that they've provided money to the school and it's obviously on the school to then provide the provision in section F, the school are then saying that they're unable to hire something like, for instance, a TA, how much time should they be given to find one and what should happen in the meantime? The local authority considers their duty is done once the plan is finalised. So once they've specified and quantified it in section F and they've named the school, the local authority are saying it's the school now have to use the funding to find the TA, but the school are taking ages to actually implement.
Well, that is an identical question almost to the previous one, and the advice would be the same. You need to send a letter before action to the local authority saying the school are not making the provision, it's in the plan. You might have given the school, the local authority may well have given the school funding, utterly irrelevant. The provision's not been made. The local authority can fight it out with the school. The idea that you can't find a TA, not acceptable. It may be you've got to increase your hourly rate, or the school or local authority have to increase the hourly rate to find a TA depending on the location. That the idea they can't find a TA to work in a school is not going to be accepted. So basically it's the same advice. Get your letter before action out tomorrow, next day to the local authority. You're in breach of your statutory duty. You know, this is the EHC plan as finalised clearly says that my child should have a TA or whatever it is for 20 hours a week or whatever, how many hours, and that's not being provided. If you do not make that provision within the next 40, you know, make arrangements to ensure that provision is made within the next 14 days, I'm going to bring judicial review proceedings.
Okay, next question. Is the word can, so in the example given is child's name can have an episode of care by the speech and language therapy service, is the use of the word can in that situation unlawful?
Well, I don't know what can means really. It should be must have or needs, isn't it? I mean, what does that mean? I think that seems a bit vague to me. I suppose, read the sentence again.
So it's, for instance, so in your case, it would be Dean Asher Smith can have an episode of care by the speech and language therapy service.
Well, what the heck is an episode of care? An episode of care, oh, God knows what that is. I don't know what that means. That is utterly meaningless to me. So if it's utterly meaningless to me, I'd say that's unlawful.
Okay, so the next question, should the school specialist independent be providing a learning plan or equivalent, and if so, how often?
Not necessarily. It depends on the circumstances. As long as they are having an annual review, by learning plan, my guess is you're sort of referring what others might call an individual education plan, which is done termly. They may, or it depends on the school, depends on the young person. What must happen is the annual review. That's the key.
So should the local authority include a provision in F that is already happening and delivering a benefit to the young person if it is specified and quantified and meets the special educational needs set out in B? Can they refuse to include it and provision something else instead? So if something's being provided at the moment that's currently working and has shown track record to working, can the local authority scrap that and provide and put forward something else?
Yes. You want it in the plan in F.
Is there a legal point in asking for the draft in a Word document, as local authorities sometimes refuse?
We've had that a couple of times. It's irritating. I'm not sure you've got a legal requirement for it to be as a Word document, but it's frustrating if it's not, because it's difficult to make changes. Yeah, I don't think there's a legal requirement, but it's real pain in the But if you don't have it, it's very difficult if you don't have it. If you don't have it, then you've just got to print it and you've got to handwrite on, it seems to me, this PDF. You've got to sort of handwrite your alterations, your comments. Yeah, it's difficult.
So this person has currently in section F, full-time named key worker support, including breaks, lunch, trip, transitions throughout the day, and to meet before and after school.
Yeah.
And they're now saying school are saying they can only support in class, and if the child leaves the classroom for time out, which he needs daily, they won't support him. They say they are providing the full-time support as the key worker is in the class, just not with him. He goes to an special autism school. They are sending him home if he needs to leave the class, which is every day. So he's only in school 8 hours. Is that actually fulfilling the provision in F, and is that actually, no? And what can the client do?
I think again it's threat of judicial review, because frankly, if that child or young person is meant to have that one-to-one support, they should go with them, not stay in the classroom. Presumably that support is staying in the classroom and helping other children. It should be helping your child. But in addition, I'd be saying, well, you know, this provision, that the actual placement's not working if the child's in school so little, and it's absolutely wrong for the school to be sort of contacting parents saying, well, you know, he's left the classroom, come and collect. I mean, no. Parents have lives and they may be working. They can't do that. They shouldn't be asking that. And if they're asking parents to come and collect a child halfway through a day, that in essence is an exclusion, probably an unlawful exclusion. They can't do that. Either they have the child at the school 9 till 3, or they exclude. And what they're doing here is saying we can't cope. Well, they can't cope because the one-to-one support is not going with the child. So there's a lot of issues going on there. I would say judicial review say you need to make the provision. The one-to-one needs to be with the child. It's clear in the plan that that child needs the one-to-one support beginning and end of day. So you're in breach there. The next point is that very concerned that there's some unlawful exclusions going on here, and perhaps it might be a separate letter on that.
Okay, can you change the format of the plan given the problems where section B fails to translate into F, which sets out provision in relation to outcomes? Can you ditch the outcomes and just do a mirror of section B? So this is where, this is where we get provision matching outcomes, not needs.
Yeah, no, F needs to mirror B for needs. It shouldn't be connected to, it shouldn't be tied in with outcomes. That's wrong. That's wrong. And we have seen that a few times recently. That is wrong.
Section F must quantify SALT and OT provision, but does the LA need to include these costs at tribunal? Is there ever case? Oh, yeah, that's two separate questions. So the first question is Section F must quantify SALT and OT provision, but does the LA need to include these costs at tribunal?
Well, they are costs, but they're going to be the costs wherever the child is, aren't they? So I always say the cost of OT and speech and language are cost neutral. So if you're arguing for a different place, let's just say the child is going to have speech and language therapy. They will have speech and language therapy for 1 hour a week at the school. The local authority is suggesting, let's just say at £80 an hour. And if they are at the school the parents want, they're going to have speech and language therapy for 1 hour at £80. It's cost neutral, although of course if you want an independent special school, usually the therapies are included in the cost. So if you're looking at an independent special school, let's say it's 60,000, the OT and speech and language will be included. But it's likely that if the child went to a maintained special school, the speech and language would be an additional cost then. So the cost issue can be complicated, but it depends whether the speech and language therapy and OT are included in the costs of the placement you're arguing about. Some schools will include it in the cost, some don't.
Is there ever cases where parents can be too prescriptive in the EHCP plan?
Well, that's tribunals do from time to time, particularly with special schools, say we want to give the school the chance to be flexible and deliver according to what's happening with the child. That's a difficult one to answer because it depends on what exactly it is that you are suggesting, or it is being suggested you're too prescriptive about, if that makes sense.
Okay, next question. How does it work if it all falls apart at school and they have to school at home until another placement is found? How quickly can the requirements or funding be changed?
Depends on the local authority, depends on what's available, depends what the needs of the child are. So there's no easy answer to that one. If you lived, for example, probably in central London, then the chances are that an alternative school could be found quite quickly because there'll be a range of schools available. If, however, you are looking for a school in a more rural location where there are limited special schools and you're looking for a special placement, then it may take longer to find a school. But the local authority have to make some provision. And if your child or young person is out of school for too long, then again, judicial review would be the answer, or threat of judicial review. The local authority have got to look for somewhere else, and they've got to issue an amended plan.
So the next question is a bit complex. So it says the child's plan lists a long list of things the child needs adult support with, but it could read that lots of different adults are helping him. The local authority is saying it's up to the school to decide which adults and when they will support him. The parent obviously wants to say that it will be a trusted, trained and experienced adults, but the local authority are refusing to change this. Is this something that they can insist on?
That's a tricky one. That is a tricky one. Again, depends on the school and young person. It depends exactly on what provision it is said is being provided. So certainly I've had this before where, for example, Dina Asher Smith has a full-time LSA or teaching assistant for 32.5 hours per week. And the school and the local authorities struggle to find a full-time LSA or TA, so they have part-time. But then you can get into a situation where that young person has 3 TAs in a week, and that can be too disruptive, or even 4 or more. I have in the past argued that, they should put in F that due to the difficulties the child has, that almost a comment along the lines of it would be preferable if the TA stroke learning, there were no more than 2 different TA stroke learning support assistants per week, but it's tricky. So with that is difficult. And it depends what the school is saying, and you don't want too many people delivering all sorts of things. So you can certainly ask that go in the plan, and it really depends on what else is an issue as to whether you, on that point, you would want to take that to a tribunal. Maybe there's other issues as well.
So the next question is the fact that the local authority are basically saying that the school have been given X amount of funds, and therefore we're not really going to make any changes to the plan because it won't make any difference to the funding that the school are getting. Well,
it doesn't matter whether it makes any difference to the funding. What you want is a plan that you could enforce. So the local authority, for example, might be giving the school 20,000 per annum, and if you get the wording changed, they might still give the school 20,000 per annum. But if the school fail to make the provision that's in the plan, you have recourse to enforcing that plan, which you don't have if it's vague, because the funding arrangement is neither here nor there to you. So you do want it quantified and specified so that you can enforce it. Funding you're not interested in. It doesn't matter. It's irrelevant whether it would change the actual amount of money that the school received. And of course, it may well be that if you've got the plan quantified and specified to be clear what your child or young person should receive, that it may actually result in increased funding to the school.
Okay, next one. Can the school use the COVID pandemic as a reason not to provide provision, e.g. providing one-to-one support, external provision such as SALT input?
Short answer is no. No. The moment they should be making the provision in the plan. There's no excuse.
And then we've just had one comment. Keith Lomax might want to interject after the questions, Bev.
Yeah.
So the next question is, if a local authority lists banding, how can you get it removed at draft, first, final, and/or at annual review?
Well, the banding shouldn't be in a plan. Some local authorities want to put it in. It's irrelevant. It's not a question of how much money is going to be paid over. So say that it shouldn't be in an EHC plan. It's unlawful. You want it removed.
So that's all the questions at the moment. I'll give it a couple of minutes, but it might be worth Keith just interjecting here on some of the legal aid issues.
Yes, Keith.
Yes. Various references have been made to judicial review, and I specialise in judicial review challenges against local authorities and do a lot of these pre-action letters and challenges. Some of them do end up in court, not many, because mostly they're resolved by pre-action. But I think the pre-action letter it is something that needs to be done properly. You best with legal advice if it's going to be effective. They are a specific document in a certain format with certain information and legal argument that needs to be there, because this is what ends up in court eventually if matter does go to court, and that's why the local authority takes them seriously and will respond. So I do advise that you take very careful note of that particular approach. In terms of legal aid, it is available for the child when issuing court proceedings, and it can be available for pre-action work. So it's really a matter of you can ask us, you can get in touch and say, you know, can I have legal aid for this work or not? It's not something that we can give a definitive answer or guidance on broadly, because there are some discretionary aspects as to how much, for example, capital in your house should be taken into account. But we do legal aid work as a firm, and we would do that as a priority, in that we don't say to someone, oh, well, you have to pay us, without advising you could do this by legal aid.
Okay, I've got a fair few more questions, Bev.
Okay. So
the next one is, my annual review was last November. The local authority agreed to amend some parts of the EHC plan. They feel their child is in the wrong school with many reasons. They used a private educational psychologist to assess him, to back up and update his difficulties, but couldn't afford the OT assessment. Is it late to have an independent OT assessment at this time? The annual review is not finalised yet.
Short answer is no. You could, if you think an independent OT report would help and is appropriate, then yes. You can go ahead, because until you get the amended EHCP, you have no right of appeal to a special needs tribunal. Once you receive that, you have 2 months within which to make an appeal. I would probably suggest in your case you make it as soon as possible. But once you've made the appeal, the special needs tribunal will then list or make a timetable for your case to be dealt with. And that timetable will provide for further evidence. So you can provide, as part of your initial appeal, the educational psychologist report that you've received, and then as further evidence you can supply the OT report, because by then you should have received it, if that makes sense. So no, it does sound to me as though it's not too late. With regards to the annual review, if the local authority should by now have issued the amended EHCP, you need to chase them and perhaps look at our talk yesterday on annual reviews, because again, if they don't comply with the timetables for issuing the amended EHCP, then again, that is because you need the amended EHCP in order to appeal. So you need to be pushing the local authority to issue it, and then you need to, if they don't, threaten judicial review proceedings. They will then issue it quite quickly. usually, and then once you've got the amended EHCP, you can then appeal. So you'll have time within which to submit your OT report. So I see, it seems to me that you've got time to try and get that.
Do you need to tell the local authority that you're obtaining an independent OT report?
No.
Okay, next one. What is the legal point for getting banding removed from an EHC plan?
Well, the legal is it shouldn't be in an EHC, but I'm not sure what the actual legal is, because there should be nothing in an EHC plan which deals with the costs. It's about provision. It's about needs and provision. There's other sections to it as well, but there's no place in an EHCP for the costs or banding.
Next question. Why do local authorities and NHS professionals refuse to quantify and specify and waste resources to go to tribunal, given it's a waste of funds?
I have no idea about that. It's been a puzzle to me for years. I don't know why local authorities do it. My guess is to save money, but it is bizarre.
If provision is no longer suitable because child is now older, can it just be removed during annual review, or should an educational psychologist be involved to suggest new provision?
Well, both really. It depends what the provision is. If you think that the provision is no longer suitable and you want it removed, you can, and if it's important to you, you can ask for an early annual review to have it removed, or you can deal with it the next annual review and ask for it to be removed. Depends exactly what the provision is as to whether you need an ed psych to recommend that or not.
Should CAM's input be in section F?
If there is a social, emotional and mental health need identified in B, and the provision to meet that need is possibly CAMS, then that should be in F.
Should a local authority include strategies within section F as well as provision?
Strategies is not really provision. Generally, depends, but it's not generally provision. It can be, for example, a strategy if a young person gets overwhelmed by sensory issues and needs to have sensory breaks, leave the classroom, then a strategy would be to allow that young person to leave the classroom and have a sensory break and walk around the playing field. But the provision would be that young person should be able to leave the room to have sensory breaks with a TA and walk around the playing fields for 10 minutes when they need to. So that might add into your provision for a TA, for example. And it might be that occasionally a young person needs a sort of quiet room to go to. And again, that would be provision, but it'd be one of the strategies used.
Okay, so another question. The educational psychologist didn't visit the child to assess in school due to COVID and instead visited in the home to assess the child. Can the LA refuse to use the wording from the report?
No. I mean, the local authorities often try and refuse the wording in an independent ed psych's report because they say it's independent. It's not independent. Well, their ed psych is employed by the local authority. That's not independent either, or certainly it's less independent. So no, that's not grounds for not including it. They're just trying not to make the provision that an ed psych has recommended, really. But that's not justified in my view. Is that all the questions? No more questions?
That's all the questions. Yeah.
Oh, we had lots of very interesting questions.
Oh wait, one more question. Always one more question. Can a therapy package for attachment disorder be included in section F?
Yes, it can, if that's what the child or young person needs. Okay, well, we had some brilliant questions today. Thank you all for joining us. I hope you found it useful. We've got our very last SEN session today, which is 1 o'clock, and really is for anybody who has any questions on anything to do with the SEN process. We won't be recording that session. If you have any questions, do join us then. We hope you found it useful. You may find some of the other sessions that we've recorded. They're going to be put on our links on our Facebook page to YouTube channel. next week, so you can look at those. We had quite a few questions where the issue of annual review became relevant, so you can, there is a whole session we did yesterday on annual reviews, so you could, some of you who joined us today may find that useful. Thank you for joining us, and goodbye.